Welcome to the LexIslamica video course series brought to you by the Advanced Legal Studies Institute, Islamabad. This course, Islamic Jurisprudence, is the first course of the series. If you haven't seen the introductory video to the course, it is advisable that you do so to get a better idea of the structure and nature of the course. The link for the introductory video has been given in the description below. This video, Defining Islamic Law, the Hukm Shari, is the fourth video of the course. Let's begin. In this video, we will begin by pointing out the two senses in which the term Islamic law may be used. The focus, however, will be on the technical meaning of legal rule, which is called Hukm Shari. The technical meaning of the legal rule is explained through its elements or conditions associated with this rule. This is followed by the elaboration of the structure of Islamic law by highlighting the relationship between different kinds of rules. The operation of Islamic law traces the logical framework through which the rule is applied to different sets of facts. Finally, the manner in which the duties are performed is elaborated along with the consequences. The following two slides cover the elaboration of the technical meaning of the Hukm Shari and its elements. The different meanings of Islamic law. Islamic law is used in two senses. Islamic law is first used in the sense of an entire system. For conveying this sense, the term used is fiqh, although the literal meaning of this term implies an understanding of Islamic law. The meaning of system is reflected in the use of the term railway, which implies a whole array of things like rails, stations, engines, signals, and so on. Likewise, the term fiqh implies legal rules, principles, concepts, standards, and the like, which are the atomic constituents of fiqh as a system. We can say that the term fiqh is being used here in a very broad sense. In the second meaning, the focus is not on the system as a whole, but on the individual rule. The legal rule is called the Hukm Shari, where the term hukm is command or communication of the Almighty. The nature of hukm must be understood to assess the exact meaning of the atomic structure of the legal rule in Islam. This means that the term hukm must be probed or understood in greater detail, for which we may turn to the next slide. The definition of Islamic law focuses on the Hukm Shari. In the previous slide, we have equated the word hukm with the command of Allah, but in reality the word hukm is much wider than the word command. That is the command of the Almighty. Hukm is actually a communication or khitab from the Almighty that deals with the performance of the duties created by the rule. In fact, we can use the phrase khitab from the lawgiver instead of khitab from the Almighty, as that will cover the Sunnah as well. Then again, some scholars might say that the Sunnah too is revelation in meaning, although the words are those of the Prophet, peace be upon him. Therefore, the use of the word Almighty is adequate. The communication creates norms of different strength. The first norm creates a binding ought, giving rise to obligation or prohibition, that is wajib or haram. This means that it is not simply a command. The second norm is lesser in strength and conveys approval or disapproval. The third norm conveys permission. The fourth norm merely declares the state of a relationship or declares how it is to work. In the fourth norm, we are talking about causes, conditions, and obstacles, and other categories. Thus, the norms give rise to performance categories like wajib, fard, haram, mandub, makruh, mubah, sahih, batil, and so on. The detailed meanings of all these categories will be taken up after we have dealt with the sources of Islamic law. Islamic law has four elements or requisite conditions. The legal rule has four elements or conditions. The first element or the necessary condition of the legal rule is the lawgiver or the hakim. The second element is the rule itself, whose atomic structure is reflected in the categories of obligatory, wajib, prohibited, haram, recommended, mandub, disapproved, makruh, and permitted, mubah. The third element is the act or performance, which is always linked to different rights. right of Allah, right of the individual, and so on. The fourth element is the subject or addressee of the divine communication. This is the individual who is required to obey the law. The four elements may be examined under the titles Structure of Islamic Law, Operation of the Law, and Performance of the Law. This is reflected in the diagram on the next slide. The elements or conditions of Islamic law. Diagrammatical depiction of the four elements. The diagram shows the four elements along with their details. The structure of Islamic law, the Hukm Shari. Obligation creating rules and rules of implementation. Legal rules are classified into two types: obligation creating rules and declaratory rules or rules of implementation. The obligation creating rule is called the Hukm Taklifi, while the declaratory rule is called the Hukm Wadi. For worldly matters, the obligation creating rule is classified into obligatory, wajib, prohibited, haram, recommended, mandub, disapproved, makruh, and permitted, mubah. From the perspective of reward in the hereafter or sawab, the obligation creating rule is divided into fard, which is definitive obligation, wajib, obligation, sunnah, recommended act, and nafl, supererogatory act. The declaratory rules include 1. Causes, conditions, obstacles, and 2. Valid, irregular, void, and so on. Initial rules and exemptions, azima wa rukhsa. The law is classified into initial binding rules and exemptions. This feature is found in every legal system, but for Islamic law, this has greater significance due to the duties pertaining to acts of worship. The word azima is used for a rule that has been made binding on us by Allah initially through the causes with respect to the lawful and prohibited when the purpose is to test us. The word rukhsa means ease and facility. Technically, it means a release after being bound for ease and facility on the basis of a legal excuse. It is not binding to act upon a rukhsa, and the subject has an option. A significant point here is that a rule based on an exemption cannot serve as a base for the extension of the law by means of analogy or another method. The reason is that if the number of exemptions increases, the main initially imposed rule will stand demolished. The operation of Islamic law. Islamic law operates through rights. Islamic law operates through a system of rights. Every issue is assigned a rule after a right that is affected is associated with the issue. For example, zakat is related to the right of Allah, while sale is related to the right of an individual. In Hanafi law, hudud relate to the right of Allah, while ta'zir relates to the right of the individual. The association of a right with the issue places the problem in its proper framework and procedure that will govern the legal problem. For example, a had penalty is deemed a right of Allah, which invokes special principles and a special procedure. Rights are classified into rights of Allah, rights of individuals, and a mixture of these two rights. The offense of qisas, retaliation, is a case of mixed rights, and so is qazf, false allegation of unlawful sexual activity. The jurists also talk about the right of the imam as distinct from the right of Allah, which is nothing but the right of the community as a whole that is today referred to as the right of state. Different procedures and even courts may be involved for such rights. According to the Hanafis, this is ta'zir at a higher level. The operation of Islamic law, causes, conditions, and obstacles. The law is implemented only if the cause and condition are found and the obstacle is absent. This is explained below. Before an issue or act can be associated with the right, the cause of the act must arise or be found. This will determine the right. For example, for zakat to be imposed, the cause, which is the existence of wealth equal to the nisab, must be found. For the penalty of cutting off the hand to be enforced, the cause of theft of an amount equal to the nisab must be found. Causes are those that have to be proved. For the law to take effect, a condition, if any, must also be found. Thus, after the existence of the nisab of zakat, the condition of haul or the passage of 1 year must also be met. In the case of theft, stealing from the hirs or place of safe custody must be met. In the case of zakat, the obstacle of existence of debts, and in the case of theft, the obstacle of being a minor must not be found. The operation of Islamic law. The law operates through legal capacities. Islamic law divides legal capacity of a human being into two parts: capacity for acquiring rights and capacity for performing duties. The two types together constitute zimma or liability. Capacity for acquiring rights belongs to every human being, while capacity for performing duties is assigned with the development of the mental faculty, for which the outer sign is the attainment of puberty. Capacity for the second type becomes defective due to natural causes like minority, insanity, idiocy, sleep, and fits of fainting, as well as terminal illness. Intoxication, jest, coercion, and mistake may affect legal capacity of performing duties in certain cases. The performance of the required act. Validity, irregularity, and nullity. An act that is obligatory, recommended, or permissible may be required to be performed in a certain manner by the lawgiver. When the act is performed properly, it is deemed as valid, sahi, otherwise it is null and void, batil. In acts of worship, if the act has not been performed properly, it has to be repeated. In contracts, the Hanafis add another category called irregular or vitiated, fasid. In many cases, such an act can become valid if the cause of the irregularity is removed, otherwise it stays suspended. It may, however, have some legal effects. An example is a contract involving riba. Under Hanafi law, such a contract is considered vitiated or fasid. This means that it can become a valid contract if the offending condition is removed. In contracts of marriage, the irregular category is employed for avoiding criminal penalties. The performance of the required act, manazil, performance and delayed performance. In acts of worship, the divine communication operates through different manazil, levels of duty, but for the law as a whole, the idea of duties is widened into the 5 or 7 well-known categories. These manazil are fard, definitive obligation, wajib, obligation, sunnah and nafil. This division pertains to the right of Allah alone, because all acts of worship pertain to the right of Allah. Sunnah in this meaning is that the subject is required to observe it and is to be reprimanded for neglecting it without the reprimand reaching the level of the fard or the wajib. The word nafil means addition or excess. Performance is viewed from two perspectives, ada and qada or qaza. The idea of ada is contained in the Quranic directive of rendering trusts, amanat. Thus, ada is surrendering of the exact thing that is rightfully due to someone. Qada is the meeting of the wajib through something that is similar to it, as in qarz. Thank you.
مولاي صل وسلم دائما